Perhaps the most damaging allegations touching on the second highest court in the land in recent times, if true. Mboya, the lawyer in whose name and account are two Supreme Court judges in court over their conduct, is back, and this time at the Court of Appeal. Mboya is alleging that orders issued last week on Wednesday by the Court of Appeal after a High Court judge, Justice George Odunga, found that electoral officers in office were irregularly and unlawfully in office were fraudulent. He says the purported three-judge bench made up of Justices Erastus, Githinji, Fatuma, Sichale and Koome did not sit. Mboya claims that only Erastus Githinji issued the orders without a formal sitting. The orders were allegedly then circulated to Koome and Fatuma Sichale to sign. The reversed orders were made earlier in the day by Justice Odunga, who found that the IEBC not sharing the list of returning and presiding officers who were to conduct the election made the appointment illegal. Mboya also claims that the appeal was never filed at the court's registry and that the registry staff were being coerced to backdate them. The Court of Appeal has since responded to these allegations by dismissing them. The Court of Appeal Registrar Serem, in a statement, says that the court sat. Serem explains that the appeal was heard and determined by the three-judge bench after it was filed at 4:30 p.m. on the same day, and the file was taken to the President of the Appellate Court, Kihara Kariuki, who certified it urgent. The application was made by one Emmanuel Wetangula for the Independent Electoral and Boundaries Commission to suspend Justice Odunga's judgment, where the three judges reasoned that the decision by Odunga had the potential of rendering the repeat presidential election irregular even before they were held. Then the judges also faulted the decision, saying, in their view, the Constitution does not expressly give the courts the power to alter the election date. But the lawyer says the statement from the Court of Appeal is not factual. Mboya says the Court of Appeal could not have convened on the 25th, which was a public holiday. The Chief Justice only allowed the High Court to deliver a ruling and the Supreme Court, which was later hit by a quorum hitch to sit. Mboya says the Court of Appeal Registry could not have opened to receive the application and there was no memorandum from the Chief Justice allowing it to sit on that public holiday. He also says the President of the court cannot order it open. Further, Mboya notes that the fact that Erastus Githinji, who is the presiding judge in Kisumu, Koome, who is in Nyeri, and Fatuma Sichale, who is in Malindi, are purported to have sat is not possible. He also questions why, if at all, the Court of Appeal judges in Nairobi were not set up for the case. And that's not all. Mboya says he has an appeal pending at the court, which is numbered 360, yet this case was numbered 246. He questions how it could have been allocated a lower number than the existing appeal cases, which are well past 360. The Registrar Serem, however, says anyone in doubt can verify the details at the court's registry. Ken Mijungu, NTV.